Good morning, everyone, and a very warm welcome to our analysis of India's 2022 budget. In this budget, we will be talking about the some of the hits, some of the misses, but overall, we're going to decrypt the budget in this interactive session. So, the Finance Minister Nirmala Sitharaman presented her fourth consecutive budget in Parliament this Tuesday. Like the last year, and in sync with digitization of the economy and digitization of the entire network, the minister delivered a paperless budget, and she read out her speech from a tablet. This is something which has been done since last year, given the decision to not require people to stay back amid the coronavirus fears. This was the shortest budget speech, but with a long-term vision to lay the foundation and give a blueprint to steer the economy of India over the next 25 years. Basically moving India from 75 to India 100 and a vision for India post 100 years of independence. In line with the vision at India 100, four priorities of development have been provided in the budget. These four priorities are, the PM Gati Shakti involving infrastructure, inclusive development, productivity enhancement and investment, sunrise opportunities, energy transition and climate action, and last but not the least, financing of investments. There has been an increased focus on digitization. For example, development of agri-tech has seen a lot of emphasis in this budget. Use of Kisan drones in public-private partnerships will help delivery of digital and high-tech services to farmers, including in crop assessments and in ensuring that there is a healthy crop which is delivered. Startups will be promoted to facilitate the Drone Shakti project, while last year the budget had anyway given a boost to the drone industry. With the use of and introduction of e-passports, overseas travel is going to become more convenient. But the biggest push involving the digital economy is the push for the digital currency. And the finance minister has stated that the digital rupee will be issued using blockchain technology by the RBI starting in 2022 and 23. This is expected to give a big boost to the economy. And as per our Prime Minister, this will revolutionize fintech, create a global digital payment system. And it is, of course, in contrast with the cautious stand of the government on digital assets and currencies. We will talk about this a little bit more when we come to the direct tax proposals, specifically with respect to taxation of virtual digital assets, which of course exclude currencies. Furthering the agenda on digitalization of the Indian economy, some other announcements also include digital university for enhancing access to students to education across the country. Also, given the recent experience, the Indian experience of online classes and online education in the last couple of years. When we talk about tax proposals, as expected, tax proposals have been muted, but this is in sync with the declared policy of a stable and predictable tax regime. And the intention is to simplify the tax system, promote voluntary compliance by taxpayers, reduce litigation. So we have seen some changes around, proposals for helping reduce litigation. Preference seems to be for fewer exemptions but lower tax rates. The revised target for direct taxes is 12.15 lakh crores, and this is for the first time that India is going to cross a 12 lakh crore target. This is commendable given, at the back of, of the corona pandemic. And therefore, most of the tax proposals surround, ease in collection and compliance by taxpayers. Let's talk a little bit more about some of the tax proposals that have been introduced. And I'll turn over to my colleague Ashish. Ashish, we've seen that more or less tax rates have been stable. But do you still see any change in some of the tax rates, and how should taxpayers really prepare for filing their tax returns in the coming year?
Thanks, Parul. On the tax rates front, like you said, they remain largely unchanged. With respect to the surcharge, which was on long-term capital gains from unlisted shares or any other assets, there has been a rationalization where they have capped it at 15%. This would mean that now for unlisted shares, the rate of capital gains tax would go down from approximately 29% to about 23.5%. And for non-resident, this would mean that the rate would go down from about 14% to about 12%, which is a great move. And it is in par with the surcharge, capping of the surcharge is in par with what was being done on the listed shares. Mind you, the surcharge at capped at 15% is for all types of capital assets on long term. The second proposal with respect to tax rates was that foreign companies, when they were giving dividends to their Indian parents, there was a 15% beneficial rate available to the Indian companies. This was done during the DDT era, but after the DDT era, now they have bought it at par with any other company, and the dividends received by the Indian company would now be taxable at 30%, which is the usual rate of tax. Other than that, on the cooperative society front, they have brought down the surcharge to make them competitive at par with companies, where the surcharge has again been capped at 15% and not at the highest rate of 37%, which would result in the tax rate going up to almost 43%. On the tax rates, this is all that is there. There have been some amendments made to the tax returns. There is an updated tax return also that an individual can file, but there are some taxes that the individual will need to pay in case he is filing an updated tax return at various times. There are different rates that have been specified for the updated tax return. That was on the tax rates that are continuing. I think moving to the virtual digital assets, Maya, can you give us a brief overview of what the amendments are all about?
Thanks, Ashish. Hi, everyone. I think one of the major changes that's come up in this budget is regarding the introduction of provisions with respect to virtual digital assets. We know that there's been a lot of discussion in the run-up to the budget with respect to cryptocurrencies. There's been a lot of action by Income Tax Department and GST Department with respect to information collection and actually sending notices to multiple exchanges and individuals in respect of crypto transactions in the last 6 to 8 months. So it wasn't a big surprise seeing some provisions being inserted with respect to taxation of virtual digital assets in this budget. Very quickly, to give an overview, there are 3 or 4 changes that are that have come through. The first key one is the insertion of a definition of what constitutes a virtual digital asset, and we'll get to what falls within it, what doesn't fall within it, maybe in a while. The second change is, of course, the notification of a special rate of 30% for any income that is derived from transfer of virtual digital assets. Now, prior to the amendments, currently we still take a position sometimes depending on the facts that it is either business income if it's trading, or if it's more of an investment that is subject to capital gains tax. And both of it are more beneficial because in one you can either claim expenses today or you have a lower rate of tax. But that did come with quite a bit of uncertainty because there was no guidance in the law as to how the treatment should be done for different kinds of cryptocurrency transactions. So that way, this is bringing 30% flat rate without being able to claim expenses or carry forward losses or set off any losses. I think brings in a lot more clarity, but also a much higher tax regime when it comes to taxation of virtual digital assets. The last 2 provisions which have been added in addition to this is a tax deduction at source, which is a 1% TDS on the transfer of virtual digital assets, and the person who is making the payment of consideration will have to withhold, and we will discuss some issues around that. And the last provision that's come through is the gift tax, where on receipt of virtual digital assets, the recipient can be taxed on the receipt of that virtual digital asset if there is a difference in value between the asset that's received and its actual value, and it's more than 50 50,000 rupees. So that's the quick overview. But quickly coming to Jaydeep, picking up on the first definition, VDA definition that has been inserted. And as an industry expert, Jaydeep, what do you think, is falls within the definition of the VDA as introduced under the law? And, what is the history for it? That the definition talks about any code, information, token or number, which is either cryptographically generated or otherwise. And it talks about, the asset being a store of unit of value, or it could even include investment related sort of securities. So, and it has to be, you have to be able to store and transfer it. So what, according to you, falls within it? Have we seen this definition before? And what are your views around that?
Thank you, Maya. So this is in fact the first legislative definition we've seen in India around this entire phenomenon of digital assets, cryptocurrencies, etc. We all know about the RBI circular in 2018, which restricted financial institutions from dealing or facilitating in virtual currencies. But even that circular did not contain an exhaustive definition from a legislative perspective. It only gave the inclusive example of bitcoins and one or two other virtual currencies. So there was uncertainty even at that stage as to when the law is talking about a virtual currency, what is it really referring to? And meanwhile, of course, we've seen developments on the international front from the FATF and other organizations, which have gone ahead and proceeded to a definition of virtual assets or digital assets, calling it by different names. Now, this being the first legislative definition, where it has drawn from largely is the 2019 Interministerial Committee report chaired by Mr. Subhash Chandra Garg at that time, which was a interministerial committee to comment on the regulatory treatment of virtual currencies, which ultimately actually recommended an outright ban of virtual currencies with criminal consequences also. And that definition was very wide. This definition also draws from that to some extent, but it is not a mere reproduction of that. There have been additions and tweaks to that definition, but it is still fairly wide in the sense of any information or code or number, whether by cryptographic means or otherwise, is obviously very wide ranging. There are certain subjective elements which come into the definition, such as whether something has the promise of inherent value, or something is a unit of account, or something is a store of value. These are all subjective concepts where different parties may view a token as having a store of value or not, or being a unit of account or not. The closest guidance we have is from the Supreme Court judgment in 2020 in the IMAI case, where they in fact recognize that various jurisdictions have noted that virtual currencies can have the characteristics of a means of exchange, a store of value, and a unit of account. But of course, the Supreme Court in that proceeding was not called upon to consider each virtual currency separately. It was considering it as a class. So going forward, when legal and tax professionals apply this provision, they would probably need to look at a particular cryptocurrency or virtual digital asset as this, as they term it, to figure out whether it is going to be seen as a store of value or unit of account. Now, the intent behind the provision may be to essentially capture all cryptocurrencies trading on crypto exchanges. That appears to be the intent, but whether there can be certain types of digital assets which fall outside this definition is something to look at. Uh, uh, there are digital assets based on real world assets as well. There could be security based tokens, there could be currency based tokens, and there could be gold based tokens. So whether by mere fact of using a cryptographic technology or fulfilling the other elements of the definition, they fall under the definition is a matter of debate. And I think the takeaway is one should not see cryptocurrency as a class per se, that every cryptocurrency is covered in this definition. It really depends on the nature and characteristics of the particular cryptocurrency. And I know, Maya, we were having a chat offline on what may be covered, what may not be covered. Do you feel there is a scope of some non-crypto elements, so to speak, like maybe in-game currencies or loyalty points or reward miles, etc., actually getting covered by this? And in which case, there would be, of course, the VDA-related tax implications following from that.
Sure. Thanks, Jaydeep. So I think, as you correctly said, I think the history of the provision, if we look at it, seems to be that the intent was always to look at cryptocurrencies and try to tax the different cryptocurrency trades that are happening on exchanges. And I think a couple of things that is coming clear from the way the provision has been drafted is, and before we get to what else is covered apart from cryptocurrencies potentially, I think there are certain things in the definition which make it clear that at least there are certain items which are not covered. So Indian currencies and foreign currencies are not covered. And something, and but that's also a definition that could be subject to expansive interpretation in the future. We have the announcement on implementation of CBDCs by the RBI this coming year. So that should likely qualify as Indian currency. And, we'll have to keep watching for movements on whether some countries like El Salvador have notified the Bitcoin as a legal tender, and whether that qualifies as foreign currency, or if there is a way that the scope of the term foreign currency or Indian currency increases, then it automatically falls outside the definition of VDA. So there is from a policy intent, it's clear that it's either a VDA or a currency, and I think where the line is drawn is something that is we'll have to keep an eye out for. Coming to does any other transaction get potentially covered under VDA? I think again the NFTs is the first bucket I think I'll be touching on, because under the definition of VDA, I think you and I just discussed the first part of the definition, which sets out some generic tests that any property qualifies for those conditions, then is considered a VDA. There is a second limb to the definition which specifically talks about NFTs, where the government at this point has not given a specific definition to what qualifies as an NFT. However, from the legislative provisions, it appears as though you have a single category of PDAs, which qualify for the test we just discussed. And then there's a second category of VDAs, which is NFTs, for which a separate notification will be made with a definition at a future point in time. So if there is, there could be questions around what happens if the notification doesn't come through. Will we still qualify? Will there still be an attempt to treat NFTs as falling within the broader bucket, or the definition that's already set out? Questions could arise, and the policy intent is not clear at this stage on what basis were they trying to make a distinction between NFTs and other virtual digital assets, and the necessity for actually putting it as two separate buckets. So that is one, but we know for a fact that at some point NFTs, once notified, will be covered. But the real concern here would be about what else is potentially covered when you have such a overbroad definition of what VDA is. While the intent has been to target different kinds of crypto, and Jaydeep, as you spoke about the different varieties in the kinds of crypto, I think apart from just merely cryptographic tokens, there has been a drive towards tokenization in general. So thinking about some of the things, additional transactions that could potentially get covered, even though that's not the intent, is anything that's tokenized could be an issue. Anything that is, for example, in gaming transactions, you have these in-game currencies and points. Now, when we take each limb of the test, is something information, a code, a number, or a token, and it's not restricted to something that's cryptographically generated. So it could be generated through any other digital means, and if it is if it has a promise or a representation of having inherent value, or if it is let's say it is treated as a unit of account or a store of value. And obviously, when we look at these tests, I mean, any kind of security, any kind of points in-game digital assets, and then these could become potentially covered going forward. So any company in the digital economy that's dealing with any form of digital assets now should be, careful in terms of assessing whether it gets covered within this definition or not. Obviously, there are certain thresholds to be met, but they're extremely broad and very widely defined. So that risk always remains. And where is this potentially likely to result in a tax exposure is because there are certain situations companies have not had to deal with in the past, which is, for example, when you're giving free tokens or promotional tokens or promotional points or any in-game sort of freebies. These were not considered assets which could have been potentially subject to a gift tax, right? Now, are we getting into a territory where we'll have to value this? We'll have to see whether there is more than 50,000 rupees worth of value being transferred. I mean, where do we draw the line could become a question mark, if this definition were to go through without further clarity. So that's something that I think generally tech companies and the users who are the recipients of these kind of digital assets will have to be careful about, because the tax exposure is likely to be on them. Yeah, so that's about it on that point.
Correct. So unfortunately, we as the public have not had the opportunity to see this definition before it was introduced, and perhaps to provide any comments on that. So there's been no iteration. Maybe on the floor of the House there may be some debate. Also, there is a scope of the central government to, by notification, exclude or include some phenomena. So we'll have to see if they actually use that to exclude or include certain things which they specifically feel are covered or not covered. But one would hope that there is some debate on the floor of the House to actually clarify this definition further, since it's still a bill. Another area of ambiguity, Maya, could be, since there is often volatility in crypto assets, at least, how does one go about the valuation? Does one take the day's high or the market rate on an exchange, and then different exchanges have different prices? And there is a TDS obligation, as well as even payment in kind is being looked at as a taxable transaction. So how does one look at the valuation aspects?
Sure, Jaydeep. I think that's the other aspect where I was quite looking forward to seeing if there would be more clarity in this budget, because this has been a pain point even in the last year. As I said, with increased actions from the tax department, I think valuation was something where there was not much guidance, and we've had to try and justify different positions before the tax authorities. Now, as you rightly said, the value of cryptocurrencies, if anybody looks at the market on an exchange, within a day, there is a lot of variation, and across exchanges on the same day, there could be a huge variation. And when we take account of global and regional sort of perspective, again, the prices vary very highly on depending on demand and supply. So what is the appropriate valuation is something that has been a question mark in the minds of the companies in the last year. And this continues to be a problem because we still don't have any rules on how this is to be done. For example, at least under when we're talking about currency, foreign receipt of foreign exchange, there are rules under the Income Tax Act and the GST to say that you will take the RBI daily notified rates, and there is a basis to try and calculate what does that INR amount come to. When there are cryptocurrency trades where it is INR to crypto, then at least there is an INR value to kind of peg it to. And of course, the tax department is likely to say that it should be the highest value or on a particular day. But if and this comes down to what systems that the companies have put in place. If they have the ability to justify what is the actual rate, I guess then that's something that we will be able to defend. But if otherwise they don't have the details, then maybe it's the daily high that we would have to adopt. So there are aspects where companies can bring in some technological solutions to at least try and defend and have the right information at hand. But when it comes to crypto, when you're exchanging, when you're buying, 2 Ether for 1 Bitcoin, for example, how do you peg it to an INR value? Bitcoin may have an independent INR value, and that may not tally with the equivalent INR value for Ether, for instance. So in those kind of situations, I think valuation becomes extremely tricky. There are some global guidelines where some countries have tried to come up with some rules. I think, and in this case, when you're talking about gift tax, when you're talking about TDS, as you rightly said, where there could be a cash and a kind component, valuation and what basis are we charging the TDS on, or determining whether even Section 56 applies in the first place. I think it will become a very crucial part of where litigation could occur if there is no clarity on this aspect. And as we have already known historically, digital assets and the global debate around intangible assets and the valuation has been an ongoing one for quite a while. So it's not a very easy thing to do when we move beyond the cryptocurrency assets. And if we look at other digital assets, I think valuation becomes only an even more complex exercise.
Yeah, you spoke about the TDS aspect also just a second ago. Maybe you want to tell us how the TDS is going to work for valuation, for VDAs?
Sure, Ashish. I think that's the last new provision that's been brought in, which is the tax deduction at source. Now it's a 1% TDS, which is very similar to the 194.0 1% TDS on e-commerce transactions. I think the intent behind this provision was to try and track where the crypto transactions were happening and to ensure that nothing was escaping the tax net. I think that's why there is a 1% TDS that has been imposed. Now, the provision itself is again slightly vague as to who has to withhold and when the withholding has to be done, right? And there are going to be quite a few practical challenges when this is implemented. So what the provision says is that the person responsible for paying consideration to the seller of a crypto asset will have to do the deduction. Now, this can only be two people in a typical, cryptocurrency sale transaction on an exchange, where it's either the buyer who's paying the consideration, who's an individual or a user or a trader, or it could be where the money is routed through the exchange. Sometimes the exchange have control over the funds, sometimes they don't. But if they have control over the funds, then they could be treated as the person responsible for paying the consideration to the seller. But in either case, I think, if we see a place where we treat the buyer or the individual as the person responsible for, discharging the TDS, that's going to create a huge compliance burden on them. I don't think that's practicable. I think it's more likely the tax department will try and see that the exchanges are the ones who are, taking on this burden and withholding taxes. But again, that comes down to whether on INR transactions, at least whether first they have the cash to pay the TDS component before they make a payout to the users or not. And on crypto to crypto transactions, this is likely to create more problems because apart from the valuation aspect, there is a cash flow issue that could be a pain point for exchanges because if you're crediting a virtual digital asset or it's a crypto to crypto transaction, and to do the TDS, the company may have to actually convert a portion of the TDS, of the crypto withheld into INR, which carries currency risk with it. Or they'll have to get the users to pay INR to then try and be able to withdraw the crypto that they have bought. So either which ways, there's going to be some things on the business side that will have to change. Companies will have to take a closer look at. And coming to even the manner in which the TDS has to be done, the timing of which it has to be done talks about there is a deeming fiction which says that the second you have registered or you have accounted for something as creditable or payable to a particular user, then it's deemed to be paid and it has to be paid at that point. Now, many of the companies, or it's possible that they are operating, it depends on what kind of wallet they're operating and backend systems they have in place. So the point of crediting this amount to the user's account, or at what point it's recorded as being payable to them, whether we need to use a dual wallet system to control the timing of when the withholding applies, these could be questions that come up, because otherwise you need to have INR at the at the time the trade is happening live to be able to discharge the TDS obligation. So there's quite a few pain points I see coming out of this. Generally, the industry was, I think, upbeat about clarity coming through, but this TDS is something that could really affect them.
Got it. And so far, we're only talking about the income tax ambiguities. Maya, how do you see any impact on GST? I know there's no express provision in the budget, but any insights or any outlook on the GST front for the crypto industry?
Sure, Jay. I think GST is also equally big concern. I think where there needs to be a coordinated, clear tax policy from the government side. So some clarity there would have also been great to see. We have seen notices go out to individuals and to others asking why crypto is not a supply of a good. Why are you not paying 18% GST on that? And so there are quite a few questions on the GST side which remain unanswered at this stage. But basis the amendments in the Income Tax Act, I think now for Section 56, for the purposes of Section 56, obviously they've included BDAs as property, and whether something being considered movable property also increases the risk of saying that it is a digital good or it is a good which is subject to GST. I mean, could be an additional question that comes out of this amendment. But yes, I think the risk is pretty high, especially for investors, and whether if they get hit with an 18% GST, and at least the 30% tax on gains is on gains. So to that extent, it's on actual gains that you make. But the GST could be on the total gross value, so could be a big hit when we look at from a user perspective, and there is no clarity on that today. But so apart from the tax portion, I think there has been a big question on social media that's been raised by several crypto company and an industry people. The big question on everybody's mind, Jaideep, is do these amendments on the tax side really signal an intent from Parliament to affirm the legality of crypto in the future? I know there's been quite a bit of debate in the past. And recently there are news reports which say that on budget day, when the tax announcements were made, there were more than 30 to 50% spike in user registrations on these platforms. So what is your view on that?
Sure, sure. And I think there's a question from Anupam also in the chat box on that. I think essentially one may have put a different spin on it in the sense that now that Parliament has possibly clarified various modalities of detailed aspects like TDS and the tax slab, that whether the outlook of Parliament is to ultimately regulate. But then that was kind of clarified in yesterday's statements by the finance minister as well as the finance secretaries, that the consultation process for the regulation of crypto assets is still in progress. There is, they say, a stakeholder document that is being circulated and discussed. But meanwhile, seeing the high volumes on the trading platforms, that they couldn't hold their hand on tax because presumably they needed to introduce a measure to for the revenue collection on that and to bring clarity on that owing to the high volumes. So they have held their hand, so to speak, as far as regulation is concerned. And even from a legal theory perspective, we all know that merely taxing a phenomenon doesn't give any cloak of legality or illegality. But one thing to clarify in the discussion in the public domain is that whether it is being legalized through this. To be clear, transactions were already legal from the beginning. Even the RBI circular did not make holding or transfer of virtual currencies illegal. they merely prohibited banks and payment institutions from facilitating the transfer through their channels. So me and you were free to transfer Bitcoin between each other, subject to other laws. So there has been legality that was clarified on the floor of the House, and the Supreme Court in 2020 has recognized a fundamental right under Article 19(1)(g) of the virtual currency exchanges. So legality has been there. It's just a question of a specific regulation. Another example is trading of, say, spot trading of gold. It was always legal, but there was no specific regulatory regime, and now SEBI has introduced a framework for trading of electronic gold receipts. So it continues to be legal. Now there is clarity on the scheme of taxation. And what is open-ended now is on a specific regulatory framework, including potentially a licensing framework for exchanges.
Thanks, Jaideep. I think it's really interesting to hear about, the ongoing debate about legality and illegality of, transacting in such assets. One issue that we have faced frequently is in the context of overseas funds. And, given the volume of trading that has happened in the last few years, there have been specific funds that have been set up to invest in cryptocurrencies and, of course, blockchain technology as well. One issue, rather not really an issue, but one aspect that I see which is coming out of this whole new tax regime is that if a person were to trade in cryptocurrencies directly, the tax rate would be 30% account of the trade. But if the investment is made into a fund, which in turn invests in the cryptocurrencies, and the fund is an overseas fund, the income is not subject to tax in India for the fund. And since the individual is actually holding units or shares of the fund, this could tantamount to capital gains tax for the individual as compared to highest tax rate bracket of 30%. But to take this discussion further, we've seen many times, even after the Supreme Court judgment, even after clarifications on the floor of the House, authorized dealers are quite reluctant to allow remittances made from India under the liberalized remittance schemes into overseas fund, even if one of the investment thesis for the fund is to invest in crypto. Do you see that changing now with this tax regime, and how do you see that unfolding?
Correct. I think thanks, Parul. There are two levels to look at it. One is as a matter of law strictly, and one is as a matter of pragmatism. So, in terms of law, now we have a definition of virtual digital asset, which in which there's been a bright line differentiation between VDAs and currency as defined under FEMA. So one thing that becomes clear is something can either be a VDA under the finance bill as it stands, or it can be currency under FEMA. It cannot be both. Now, assuming there is a particular token which is not currency as defined under FEMA, then the question is, what is it under FEMA? And that's something where the current finance bill doesn't really go in that direction, because there's no provision under FEMA. And RBI has also kind of held its hand under FEMA and not provided clarity on the treatment of virtual currency. In fact, it says so in an RTI response that virtual currency is not currency under FEMA, and hence no guidelines have been framed for virtual currency under FEMA. So because of this lack of clarity under FEMA and in the FEMA guidelines by RBI, possibly the ADs are being conservative in terms of uh, 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 allowing any remittances, and that comes to the level of pragmatism here as to whether, now that there is a defined category in the finance bill, whether they would see it differently. But to the situation you mentioned in terms of investment in units of a fund, that is a category which is expressly recognized in the LRS scheme, where individuals are permitted to invest in foreign securities. It is a permitted capital account transaction subject to other limits like the $250,000 a year limit. So it doesn't appear that an AD would have discretion as of today to actually say that certain types of funds are permitted, certain types are not permitted. Of course, they may have their internal risk policies, but as a matter of law, one could potentially convince an AD or go to another AD for that. Some ADs, in fact, though, have formalized this view in the form of their A2 declarations. One or two prominent major banks among them as well, saying that any investment under LRS shall not go into an entity which is for the purpose of investment into virtual currency. So where it is formalized in that manner, it is potentially a matter of internal policy. But as a matter of law under LRS, if it is a foreign security as defined under FEMA, then it is very reasonably arguable that it's a permitted capital account transaction.
Thanks, Jaydeep. And I think after discussing so much on crypto, I think there are quite a few other updates in the budget that we're looking to cover as well. So I think there have been a few benefits provided to startups and some relaxations in respect of payments being made to individuals because of the COVID pandemic, which I think was of some concern to some employers and companies last year. Ashish, could you throw some light on that?
Sure. Thanks, Mia. With respect to the startups, the budget effectively provides that any eligible startup which was established before 31st March 2022 was given a tax holiday period of 3 consecutive years out of the 10 years from the incorporation date. Now, they have considered this, and considering the pandemic, they have extended this benefit for any startups incorporated prior to 31st March 2023, which means an additional 1 year has been given for any startup to register, and then they could use this tax holiday of 3 consecutive years out of the 10 years from the incorporation date. With respect to individuals, after the second wave, there was a press release that was issued by the CBDT, which effectively provided relief to individuals who were receiving monies from their employers or family members with respect to treatment of COVID or due to death of the individual. And there was a big concern whether this is going to be taxable or not. And to clarify that, this press release was issued, which effectively said that the monies received from the employers or the family members of the deceased would not be taxable in their hands. So, in order to effect these changes, there has been legislative changes made to the Finance Act, to the finance bill, I'm sorry, wherein the money is received by the employee in terms of any medical help due to COVID that was received by the employer is not taxable as perquisite, and consequently, Section 56, which taxes any sum of money received by the recipient for no consideration, also has been amended to say that if any sum of money is received by any individual in respect of an expenditure actually incurred by him for his medical treatment is not covered under Section 56. And on death of the individual, any money received by the any money received by the family members from the employer of the deceased is also not taxable. And any money received up to an sum of approximately $13,000 from any person to the family members of the deceased has also been tax exempt. These changes have been retroactively these will be retroactively effective from 1st April 2020 to take into account when the first wave also started. I think this was it on the changes with respect to the pandemic. Paul, can you tell us about some changes to the GIFT, IFSC, and other changes in the budget this year?
Yeah, sure. Thanks, Ashish. So, where the private equity and venture capital industry is concerned, of course, there have not really been any announcements as such with respect to proposed changes, but there have been, there have been a couple of important, announcements that came in the budget speech. Now, government-backed funds like NIF and SIDBI fund of funds have been providing a lot of capital to private funds or funds which are managed by private fund managers. They typically put in money. SIDBI Fund of Funds typically puts in money for startups. And in this budget, the finance minister has recognized and wants to encourage sunrise sectors, focusing on climate change, deep tech, digital economy, pharma, and agri-tech. So the government has decided to promote thematic funds for blended finance, where the government share is going to be limited to 20%. And these funds are going to be managed by private fund investors. This is an extremely important announcement from two perspectives. The first perspective means that currently we do not really have a very set regulatory regime for setting up thematic funds. The AIF regulations are not geared on a complete basis to allow fund managers to set up thematic funds. They probably have to set up separate funds for separate themes, and that can result in huge compliance related issues as well as investor management issues. It's hoped that with government backing thematic funds, which seem to be the flavor of of the year, probably some changes may come out in the AIF regulations to promote thematic funds. The second important announcement which has come is with respect to setting up of an expert committee to look into issues on the regulatory front and any other front which are faced by private equity and venture capital industry. Now, for people who are aware of how the private equity and venture capital industry functions, GST on management fee as well as at least management fee for capital managed of foreign investors, as well as GST applicability on carried interest has been a very sticky issue. Also, with changes in income tax law over the last few years, there is also not sufficient clarity on characterization of carried interest income, which is earned by a manager. The industry has approached, PMO for getting adequate clarity, and suitable representations have been made. While there have not been any specific announcements with respect to changes, but it is hoped that this expert committee is going to actually plug this issue once and for all for clarity on GST as well as manner of taxation of carried interest. Let's talk a little bit about GIFT City. GIFT City is something. It's a project which has been very close to the government's heart. And where GIFT City is concerned, we've already seen a lot of changes in order to encourage new units to be set up in the GIFT City. In this budget, the announcement has been made for setting up a world-class foreign universities and institutions in the GIFT City. And these institutions are going to be free from domestic regulation. So the education industry within the domestic setup is highly regulated, but universities set up in the GIFT City will be free from such regulations. Of course, one needs to wait and watch for the actual regulations which will be issued by IFSCA, the International Finance Service Center Authority, to see in what manner this comes out. There is also an International Arbitration Center which is proposed to be set up for timely settlement of disputes. And lastly, the FM has also announced that services for global capital for sustainable and climate finance will be facilitated in the GIFT City. Apart from this, there have been some small changes with respect to exemption for income arising from offshore derivative instruments for non-residents, which are entered into with an overseas, with an offshore banking unit. There is also, there is also a change to provide that the provisions of taxation of premium under 5627B, which typically applies, this is what we've historically called as the angel tax. This shall not apply to a category 1 or 2 AIF which is registered in GIFT City. The exemption till now existed for all funds registered category 1 and 2 registered with SEBI. Now this has been extended to funds set up in the GIFT City as well. And the reason why this is relevant is because GIFT City, which is a kind of a mid-shore jurisdiction, follows a hybrid regulation mechanism. It's considered to be a foreign person from the perspective of FEMA regulations, but it's considered to be a person resident in India from the perspective of Income Tax Act, and hence, therefore, this clarity was important. There have also been some incentives announced for encouraging portfolio management in IFSC as well as for ship leasing. At the same time, what has not really come out and what was expected was, some clarity around, allowing fund managers to hold shares of, managers set up in GIFT City, and ease of setting up the GP structure in GIFT City without obtaining an RBI approval. That is an issue which still remains. But overall, I think, Ashish, to your question, this is something to wait and watch out for this year.
Sure, thanks, Parul. Maybe you can also throw some light on how the budget is going to impact M&A and transactions.
Right. So 2021 has been the year of M&A globally as well as for India. The quantum of transactions and the value of transactions which India has seen has been unprecedented. It's also taken a huge FDI leap for India, and also, expectation of growth rate is 9.2% because of the, the pace at which the economy is growing. At the same time, we've not really seen much of changes where M&A transactions are concerned. Some, couple of issues have been ironed out with respect to mergers and demergers to facilitate, a resulting company or a merged entity to file its income tax return within 6 months from the date of receiving an approval order from the NCLT. The reason why this is relevant is because there is also always an in-between period, from the time when a scheme is filed with the NCLT for a business reorganization, which includes a merger or a demerger, and the time when the scheme actually is passed. The in-between period is sort of a period where the entity which is getting reorganized actually carries on its business on behalf of the succeeding entity. And so to provide some sort of ease and compliance, there have been 2 changes which have been made. The first change is for the successor entity to be allowed to file its income tax returns for the prior period, even though the actual timeline would have expired. And the second is that, if any tax assessments have taken place against a predecessor entity, then those would be regarded as being carried out against the successor entity. These are important changes, and while these would be typically included in a scheme of reorganization before the NCLT, but nonetheless there would still be hiccups in dealing with this when it comes to the actual tax officer. Another change which has come out is with respect to dividend stripping and bonus stripping transactions. Now, there already existed a transaction which contained provisions for dividend stripping and bonus stripping, which were attempts by an investor to invest in securities at a particular point in time, receive bonus units or receive tax-free dividend income, and then sell off the original security at a lower price in order to book a loss. This was not earlier applicable, for bonus stripping. The rules were not applicable earlier for shares, and it was more relevant for units of mutual fund. Now this is applicable even for shares. So a lot of investors, for example, FPIs or other investors who invest in companies, just before a bonus issue has been announced, and then sell off the original shares, book a loss, and then set off the loss against their other derivative income, will need to keep these provisions in mind. These have also been extended to units of a REIT or an InvIT as well as an AIF. But for an investor to really gain from bonus or dividend stripping rules, a secondary market needs to exist. And so therefore, probably these changes will have lesser relevance in case of close-ended AIFs as well as unlisted or private REITs and InvITs. I think last but not the least, there is also a provision which has been introduced to allow, a person who has withheld taxes and under an arrangement with the recipient of the income that the payer needs to bear the taxes. Now, we've seen this in a lot of transactions where, the commercial arrangement in a transaction is that the payer of the income or the purchaser of securities would agree to bear the withholding tax on the transaction. And taxability, non-taxability of the transaction is always a negotiation point, especially for grandfather transactions getting covered under a Mauritius or Singapore tax treaty. Under the new rules which have been proposed, or the new provision which has been proposed, the person who has withheld the tax can make an application to an AO or the tax officer, asking for a refund of tax on the ground that the tax was not required to be deducted. And the assessing officer or the tax officer will need to pass an order within 6 months from the time that this application is received. So this just eases compliance, or eases the facility for getting refunds for persons who've agreed to bear taxes in case of these type of transactions.
Thanks, Parul. Ashish, coming to the government has been working on reducing tax litigation for years now. Any measures this year that you'd like to quickly highlight?
Sure. I think considering time, I'll keep this short. With respect to any appeals that are going to be filed by the department in case of a favorable order that the taxpayer receives at the commissioner level, there has been rationalization to reduce this litigation, essentially to say that if there is a question of law which is similar to the case of the taxpayer pending before the High Court or the Supreme Court, then there have been some measures that are proposed, which is going to allow the commissioner to tell the assessing officer not to file an appeal at this time. Only once the question of law has been determined, then a call can be taken whether they want to file the appeal or not. This will substantially reduce litigation in India, because there is rampant appeal filing from the department side in case of a favorable order that the taxpayer receives. So this is going to go a long way in perhaps solving that problem. There has been a rationalization also of the provisions related to reassessment. I will not go into details, but last year the reassessment proceedings were revamped, and there has been some minor tweaks that have been made to rationalize these provisions. Other than that, there has been a little bit of a change to the dispute resolution committee, where they have allowed the assessing officer to pass an order to give the effect of the dispute resolution committee. This was earlier not there and now has been brought in. Last, with respect to litigation, is the faces assessment. Last year, they had introduced the faces assessment in the Income Tax Act. Now they have again revamped these provisions and brought about the change in procedure, basically to make it simpler and to solve for the problems that were being faced in the last year. Notably, among one of the changes that they have brought about is that there was a provision last year which said that if the proceedings were not conducted in the manner that they are supposed to be under the Act, then they would be considered to be not void. And the High Courts had, ruled on this and considered a couple of the assessments to be non-est. And now they have actually removed that provision so that, the assessments don't become void, and the first year assessment can take place continuously. This is all from the litigation front.
Thanks a lot, Ashish, for this good and quick summary. I think we have our founder, Mr. Nishith Desai, also present, for this panel. Nishith Bhai, would you like to say a few words on, your take on the budget, and, we'd love to hear your thoughts.
Only a few things. I know time is going fast, so thank you, audience from all over for joining us this morning. I really appreciate it. Quickly, I hope you found all of our expert lawyers' comments very useful. The point I would like to make is, I think if finance minister next year, can announce, you don't need to have finance bill in a secretive fashion and coming up presented along with the budget. It can be independent exercise as well. And there should be a little more discussion on the budget, and also the provisions, because many a times when we see a lot of changes coming in, some are good, some are not so good, some may be liked by some people, some may not be liked, whatever it is, right? It would be very important that there is sufficient time provided for discussion, because as I mentioned, many times well-intended provisions is very poorly drafted, and there is not enough time for discussion on those and then it becomes a law. And once it becomes law, then you have to deal with that. So I think one suggestion I have is to delink the finance bill from the budget exercise. Okay. And if we can do that, that would help us a lot. It's very important that drafting, improves a lot more, especially in the matters of taxation. It could be hit or miss. It sometimes government also may not benefit out of that, and I think it's very important to do that. I think that is my main comment, that we don't give enough time, to the people to think about it. And the discussion is very short in the parliament. If you can just get some of those creases ironed out, that would be very helpful. And there is a lot more, but then not this time. We'll talk again. Thank you. Thank you very much for joining this morning.
Thank you everyone for joining us. That's all we have on the budget analysis today. Please visit our website, nishithdesai.com, for a detailed write-up on the analysis. And, if there are any questions that you still have, please feel to write to us at taxteam@nishithdesai.com. Thank you so much for your time this morning. Bye.